The Ninth Circuit Court of Appeals has just reversed its previous decision overturning the Oregon anti-recording law from a lawsuit that I filed in 2020. The ruling is called an banc ruling. The Oregon privacy law requires the consent of all parties to record. The Ninth Circuit had ruled in our favor in July of 2023. Breaking news, the Ninth Circuit Court of Appeals has struck down Oregon's recording law on the grounds it's unconstitutional. But it just reversed itself Tuesday in a ruling called an banc ruling, now finding that the law previously overturned is constitutional. The legal battle surrounding this is regarding Oregon's recording law 165-5401C. Prohibiting unannounced audio recordings. Now, I believe that all these two-party recording laws are unconstitutional because I believe it should be legal to record a conversation when you're physically with the person you're talking to. After all, recording the conversation with the person you're talking to is closely tied to your right to repeat what it is that you were told, except the recording of the conversation is more accurate than a written down version of the conversation, or worse, your memory of the conversation. And my lawyer and I, Ben Barr, filed this lawsuit in Portland, Oregon in August of 2020. Here's pictures of us wearing a bulletproof vest at 9, 10 o'clock in the morning because the previous night Antifa was burning down buildings in that neighborhood, but they were all asleep when we walked to the courtroom. The en banc panel, Ninth Circuit Court of Appeals, believe that Oregon has a, quote, significant interest in, quote, ensuring its residents know when their conversations are being recorded. Instead of policing what conversational privacy might be, how narrowly it might be defined, or the like, the en banc panel just agrees that all conversations in public should be protected without asking what's private and what's public. It should all be protected. How do we stretch privacy to such an absurd definition? Oregon's law designed to protect privacy. Oregon decided the good news, what the powers that be wants you to share, you can't report unsanctioned information, and that's what journalism is all about. Now, this panel of Ninth Circuit judges disagree with me. Chief U.S. Circuit Judge Mary Murgula, an Obama appointee, as well as U.S. Circuit Judges Kim Wardlaw, a Clinton appointee, along with Jennifer Sung, Anthony Johnstone, Anna D'Alba, Rupali Desai, and Gabriel Sanchez, all Joe Biden appointees in the majority. There's only one judge appointed by Donald Trump, Mark Bennett, who agreed. The two Trump-appointed U.S. Circuit Judges Kenneth Lee, Daniel Collins dissented, writing the Oregon law was overbroad and banned the taping of conversations where there was no reasonable expectation of privacy. Ben Barr and I saying we intend to take this issue to the U.S. Supreme Court through a writ of certiorari, requesting the court review this because the laws across the country differ. And the courts all disagree. Now, Ben Barr argued before the Ninth Circuit Court of Appeals. That's on video. There's one section here where Ben Barr argues that Oregon's definition of privacy is just plain goofy. Ben Barr also discussed before this panel of judges the problems with the Oregon law.
Imagine if we had a different rule, if that had gone a different way. The government would be able to place a tax on ink for newspapers, but the Supreme Court said no to that in Minneapolis Star. It would be able to ban contributions and limit independent expenditures, but the Supreme Court said no to that in Buckley.
Again, I signed the lawsuit in 2020. Here's my signature when I was at Project Veritas. This lawsuit has the full support of Citizen Journalism Foundation, and I intend to assist in getting amicus briefs in support of Benjamin Barr and this lawsuit. Stay tuned.